Foster and relative care can be an obstacle course, but with the right guide, a caregiver can successfully cross the finish line. This training drill will help you go over, under, and through any obstacle you'll find along the way. Welcome to the Foster and Relative Caregiver Training Drill on juvenile court hearings and multidisciplinary team meetings. This should take you approximately 30 minutes to complete and is approved for 30 minutes of training hours. Be sure to print the completion form before you begin this video. You will need this form to answer your checkpoint quiz questions as we progress through the training. If you're ready, here we go!
Hello and welcome to the training for foster parents on juvenile court hearings and MDTs. Today we're going to talk about a foster parent's role in the court process, including confidentiality, speaking and testifying at court hearings, and speaking at MDTs and making recommendations at MDT meetings. First, a juvenile court case is comprised of many people that are all part of one team. The function lies in the ability of the members to work as a team and help support each other. The foster parent is an integral part of that team and ensuring that all stakeholders know how the child is doing in the home and hoping and working with is supporting the biological parent if needed. Your attendance at team meetings is valuable to the child, the biological parents, and the team. You are not a party to the action, but are a member of the MDT teams and have right to notice of court hearings and an opportunity to be heard at court hearings. Without your involvement, the team will not have success. I want to start with talking a little bit about confidentiality. It's very important in juvenile court case that confidentiality be followed and remembered at all times. Both the court rules and the statutes set forth confidentiality laws that protect children and families in juvenile court. Just the fact that a child or family is involved in a proceeding in juvenile court is confidential. Further, the statute makes it a misdemeanor crime to not keep records from reports and investigations of juvenile court cases confidential. This confidentiality includes any information that you may receive in MDT meetings. Foster and relative caregivers must also understand that this confidentiality does not apply to sharing information about the child's current case with the DFS worker and GAL. This may include their current care, medical needs, visitations, etc.
So you've learned about confidentiality. Let's take a quick quiz on what we've discussed so far. Which of the following statements are false? A. Juvenile court proceedings are confidential. B. The fact that a child is in a juvenile court proceeding is confidential. C. Information shared at a MDT meeting is not as confidential as the court proceeding. Or is it D. Confidentiality does not apply to sharing information about the child with DFS and the GAL? Please take a moment to think about your answer. If you chose C, information shared at an MDT meeting is not as confidential as the juvenile court proceeding, then you are correct. The information at an MDT meeting is protected by the same confidentiality laws as the court proceeding.
Next, we're going to talk about court hearings, foster parents' rights, testifying at court, presenting information at court. The Adoption and Safe Families Act, passed by Congress in 1997, states that foster parents must be given notice of and the opportunity to be heard in any hearing held with respect to the child. This means that although caregivers can go to court and present information, they are not parties to the action and do not have the same legal rights as the Department of Family Services, the child's birth parents, or the child. Also, although they have the right to attend, caregivers are not required to attend those court hearings under the law.
So you've learned about foster parents' rights. Let's take a quick quiz on what we've discussed so far. Which of the following is a foster parent right? Is it A, to be given notice of court hearings, B, to attend court hearings, C, to be given the opportunity to be heard at court hearings, or is it D, all of the above? Please take a moment to think about your answer. If you answered D, all of the above, then you are correct. Foster and relative caregivers have the right to notice of hearings, the right to attend hearings, and the opportunity to be heard at court hearings, even though they are not parties to the juvenile court action.
If you attend court, some judges may limit your attendance to answering any questions that they have about the child, and they may not allow you to make a statement. Other judges may allow you to make a statement. When making a statement, remember that the court has a limited amount of time, and your comments should be short and to the point. It is helpful to provide factual information, describe behavior you observed in the child, and present information about the child's needs. You should focus on giving first-hand information about the child in your care, and not offer opinions about other people involved in the court process, such as the DFS worker, the child's birth parents, and the attorneys involved in the case. Some information that the court may find helpful is placement information and a brief description of the child's physical and emotional condition at that time, medical information, including doctor's visits since the last court hearing and the result of those visits, any medications the child is taking and the dosages, any adverse reactions that the child has had to any medications or procedures, and a brief description of the child's physical development and any developmental lags you have observed. Dental information, including visits to the dentist since the last court hearing and the results of those visits. Educational information, including the child's grade in school and whether the child is performing at grade level, the dates of any school conferences you have attended and the results of those, especially if the child is in special education classes and on an IEP, and any educational testing that the child has had and the results of those testings. Behavioral information, including a brief description of the child's behavior in your home, any services the child is receiving to address behavioral difficulties, a brief description of how the child expresses his needs and feelings and how he calms himself, and a brief description of the child's eating and sleeping patterns. Visitation, including the dates of visits between the child and their parents or other family members. If you have supervised those visits, a brief description of the behaviors of the child and the other family members present at the visit. Be sure to carefully describe only the behavior, not comment on the reasons for the behavior. Also, a description of any arrangements for sibling visitation and the dates of any telephone contacts between the child and the child's family members and parents. Professional contacts, including in-person and telephone contacts between you and the child's DFS worker, the child's GAL, and the child's court-appointed special advocate, if there is one. And finally, recommendations, a brief description of any services you believe the child would benefit from and why. At some point, you may be called to testify at court. Foster parents are sometimes called as witnesses in juvenile court proceedings. If you're going to be called as a witness, one of the attorneys involved will generally contact you to tell you that he or she plans to ask you some questions in court. In some cases, you may receive a subpoena, which is a legal document that the court issues telling you when and where you must come to court. In court, after taking an oath to tell the truth, you will sit in the witness stand and answer questions from one or more attorneys about what you saw or sometimes about what you heard. Some tips for testifying in court are to be sure that you're always telling the truth, that you dress professionally as you might for a job interview, that you're organized and prepared, that you're calm and sincere, especially if you are challenged or criticized, serious and polite, that you listen carefully to each question, pause, think, and then respond directly to the question. You'll need to wait until the question is completed before you answer. If an objection is made about a question by an attorney, wait to speak until the judge decides whether or not you should answer the question. If you do not answer a question, ask the lawyer to rephrase it. Answer each question completely. Be sure of the answer that you are giving. Offer to explain your answer if it's necessary. Be sure you're using language that you are comfortable using in everyday life. Listen carefully when the other people in the courtroom are talking. And finally, always show the highest respect for every person in the courtroom, especially the judge.
So you've learned about testifying in court. Let's take a quick quiz on what we've discussed so far. Is the following statement true or false? Some judges may limit your attendance at court to answering any questions he or she has about the child and may not allow you to make a statement. Please take a moment to think about your answer. If you answered true, then you are correct. Although you have the right to attend the court hearings and an opportunity to be heard, not all judges will allow you to make a statement in court. They may limit your involvement to answering any questions they may have about the child.
The final topic for our training today is the multidisciplinary team meetings and how foster parents are involved and what statements they should make at these meetings. MDT meetings are required by statute in abuse neglect cases, CHINs, and delinquency cases. The statute requires the court to appoint an MDT within 10 days of the petition being filed. The MDT must include the following people per the statute: the child's parents or guardians, a representative of the school district, and if the child is on an IEP, that must be a member of the IEP team, a representative of DFS, the child's psychiatrist, psychologist, or mental health professional, the district or county attorney or their designee, the child's attorney and/or their guardian ad litem, the court-appointed special advocate, if there is one, and finally, the foster parent. The statute also includes a list of people that may be included as part of the MDT team, but the court must appoint them as part of that MDT team for them to be present at the hearings or make any recommendations. These include the child, a relative of the family, a representative of the Department of Health's Behavioral Health Division if there are special needs for the child or parent in substance abuse, mental health, or developmental disabilities, other professionals or persons that have particular knowledge of the family that include linguistic, cultural, or disability needs, and any other lay members that the court deems necessary.
So you've learned about members of an MDT meeting. Let's take a quick quiz on what we've discussed so far. Which of the following types of individuals are statutory members of the multidisciplinary team meeting? Is it A, the foster parent, B, the child, C, a representative of the Department of Health's Behavioral Health Division if special needs for the child or parent are present, or is it D, none of the above? Please take a moment to think about your answer. If you answered A, the foster parent, then you are correct. Although the foster parent is not a party to the court proceeding, they are statutory members of the multidisciplinary teams. The other individuals listed, including the child, are optional members of the MDTs and are only members if the court orders it.
Some general information about multidisciplinary team meetings are that the purpose of an MDT team is to present recommendations to the court. In formulating recommendations, the team must give consideration to the best interests of the child, the best interests of the family, the most appropriate and least restrictive case planning options, and the cost of care. Remember that MDTs are confidential. Also, if a child is placed in out-of-home care, the MDT team must meet quarterly. The following are items that the MDT team might want to know about from the foster parent, and they may consider it useful in making recommendations at an MDT meeting. Any safety concerns you have about the child's current health and well-being, the child's educational status, behaviors of the child before and after visitations, changes in child or foster home since the last MDT, and the child's contact with the biological parent. Finally, at the MDT meeting, you'll be asked to make your recommendations. Typically, the MDT coordinator, who is either a third-party facilitator or the DFS caseworker, will allow each team member a few minutes to give an update to the group, and either during the update or after everyone's update, each member will be asked to make a recommendation or agree or disagree with the DFS worker's recommendation. Remember that if someone asks for your recommendation before you are ready to state it, for example, maybe they ask you before everyone else has given an update, and you'd like to hear everyone else's updates before your recommendation. Feel free to ask to give your recommendation at the end of the meeting. There's no requirement on the time for you to give your recommendation.
So you've learned about MDT recommendations for foster parents. Let's take a quick quiz on what we've discussed so far. Which of the following are items the multidisciplinary team meeting might want to know about from the foster parent? Is it A, the child's current health and well-being, B, any safety concerns, C, the child's educational status, or is it D, all of the above? Please take a moment to think about your answer. If you answered D, all of the above, then you are correct. There are many items the MDT might want information on from the foster parents, including the child's current health and well-being, any safety concerns, the child's educational status, and more. Congratulations! You made it to the finish line. Be sure and submit your completion form to your foster care coordinator in order to receive training hours for this video. Thank you for your time. We hope that you have found this helpful.